In this lesson, we will begin our discussion on copyright law, which makes up one of the fundamental pillars of intellectual property. By and large, copyright law relates to the rights of authors of literary, artistic, and scientific creations. These are collectively known as works. Now, the primary premise, or what you need to understand at the very outset, is the fact that you have a primary category of protected works and you have other works which can be considered as derivative works, which fall under the category of other protected works. So on the one hand, these primary protected works, no matter in which jurisdiction you may be studying intellectual property law in, fall under, on the one hand, books, pamphlets, articles, computer programs, and any other type of writing, speeches and lectures, things which are delivered, so to speak, dramatic musical works, choreographic works which are meant for stage, audiovisual works, these entail video productions as well, photographic works, drawings, paintings, sculptures, etc. Conversely, these other protected works, things which fall under the derivative category as I'd like to consider them, are basically translations, adaptations, and any other transformative works of those discussed previously. Now, the discussion stemming from these protected works and in relation to copyright law as a whole is firstly discussed by manner of considering the nature and scope of the works in question. Now, previously we discussed that these types of works fall under the protected works as well as any other derivative forms. In order to determine whether they are protectable, so to speak, we need to consider several different factors. Firstly, we need to consider if this particular work is original, or in other words, its originality. The copyright protection only covers original works of authorship. Originality in this context is concerned only with the expression of ideas and not with the ideas themselves. In essence, we are considering when an idea has been put down on paper or has been communicated or presented in some form. Merely having the idea itself does not amount to originality. A seminal case in relation to this can be seen in University of London Press and University Tutorial Press, where it was held that original does not mean that the work needs to be original or an inventive thought. Work must not be copied from another work. It should originate from the author. Secondly, the expression of the idea is paramount. Copyright law does not protect ideas themselves, just like the component of originality that we looked at a moment earlier. It protects the presentation or the manifestation of those ideas. Thereby, the third element that we must consider is in which form this expression is made. A work receives copyright protection irrespective of the form of its expression. As long as it's expressed in a discernible manner, it is protectable. It does not necessarily consider the context or the content, the quality, and or the purpose, primarily on the grounds of the fact that copyright law works on the originality of the author, whether it was something planned for. The next element which must be considered is whether or not copyright protection requires any sort of formalities. And by and large, irrespective of the jurisdiction in which copyright protection is entailed, it tends to be automatic. Therefore, there is no formal requirement of registration needed. In Walter and Lane, it was noted that a work is protectable irrespective of if it were wise or foolish, correct or not. The next element which is fundamentally important to understanding whether a particular idea which has been expressed by an individual, by an author, is valid and is protectable is whether it comes in a material form. In other words, whether there is fixation. Now, in essence, fixation of a work in material form is by and large not required. But in reality, when you consider the practical application of copyright protection and any type of work for that matter, copyright law itself protects expressions of ideas and not the ideas themselves, as we looked at a bit earlier. This in turn means that there is an implicit fixation in material form And therefore, while fixation itself is not considered as a requisite, it automatically becomes a requisite by virtue of the fact that expressions are needed. The next element, which is fundamentally important then towards copyright protection being applicable, is whether it is published, whether there is some form of discernible content which has been communicated. Now, publication of a work is not necessarily a prerequisite. And by publication, what is defined in the context of intellectual property law is that a particular work by an author, an original work by an author, has been made available to the public at large. Now, what must be understood here is that copyright protection need not be communicated to the whole world. It need not be something that the author makes aware to for each individual out there. In essence, the very fact that it fulfills the criteria we've looked at up to this point, from originality, from the fact that it's protectable under the conditions of the types of work we considered, that itself would suffice. One of the more interesting aspects that we need to consider, rounding off the protectable types of works that we have looked at thus far, is the assessment of the whole work itself. Now, in relation to this, the seminal case of Sawkins and Hyperion Records comes to mind, primarily because of the dicta in Sawkins which notes that the copyright itself involves an assessment of the whole work, and it is wrong to make that assessment by dissecting that whole work into separate parts. Basically, the idea that has been communicated by their lordships in Sawkins is the fact that in order to assess whether a particular type of work is protectable and therefore has protection under copyright law as per intellectual property conditions, it must not be considered out of context, and it must be considered only by assessing the whole of the work rather than the sum of its individual parts. Now that we have identified the types of works that are protectable in relation to copyright law, in the next lesson, we will continue our discussion by firstly identifying the types of works which are not protected, why they are not so protected, and what type of rights, be it economic or moral rights, which are protectable in relation to an author. Thanks a lot for watching this video. Click on a subject of interest to learn more.